Hello and welcome to another episode of the Lexbe webinar series, your destination for sharp, timely, and practical guidance on eDiscovery, generative AI, and digital forensics. I'm Jeff Fugit, Chief Revenue Officer here at Lexbe, and I'll be your host for today's session. As electronically stored information continues to dominate modern litigation, getting the ESI protocol right isn't really just a best practice, but it's often the difference between clarity or chaos in discovery. Fortunately, we're joined by one of the foremost authorities in the field, Craig Ball, a trial attorney, certified forensic examiner, and educator at both the University of Texas and Tulane Law School. Craig brings a rare blend of courtroom experience, technical mastery, and practical insight to the complex world of ESI. Joining Craig will be Gene Albert, CEO of Lexbe. Gene is an eDiscovery expert, a former litigator, and a serial entrepreneur. So let's dive in. Our webinars take place monthly and cover leading-edge issues in eDiscovery, generative AI, and digital forensics. If you experience any technical issues, don't stress, just shoot us a note to webinars@lexbe.com and we'll jump in to help. We'll be sharing a recording, a slide deck, and a podcast version of today's session. So keep an eye on lexbe.com and on our YouTube channel. And yes, we want your questions. Just drop them into the Q&A panel on the GoToWebinar interface, and we'll answer those at the end of today's session. So for those of you that are new to us, we'll just do a quick introduction to Lexbe. Lexbe has spent over 19 years helping legal teams win document-intensive litigation, and we do that with the most advanced GenAI deployment in eDiscovery. We have Lexbe Pilot, Lexbe Autopilot, and Lexbe Copilot. Lexbe Pilot does full case analysis with GenAI. I'll show you an example of that here in just a minute. We have Lexbe Autopilot, which does automated document review for responsiveness and privilege, and actually codes out the issues as well. And we have Lexbe Copilot, which is your GenAI-powered assistant that's built into every Lexbe plan at no extra cost, so it helps you as you go through your document review. Once you've agreed on an ESI protocol and collected the data, Lexbe's GenAI-powered eDiscovery platform can help you instantly understand what's in your dataset, where the hot documents are located, and give you an entire summary of the case at the click of a button. Here's an example of that report generated by Lexbe Pilot from the Deepwater Horizon case. It tells you all of the entities, gives you a summary, it creates a timeline of events, and it even provides causation. It is the ultimate early case assessment. And whether you've got millions of documents in your case or a few thousand, this report will run in about 5 minutes, thanks to our advanced GenAI architecture. And this is way more impactful than what we've seen from legacy technologies or typical linear document review platforms. One of our clients had only 2 weeks to review over 50,000 documents to comply with a production deadline. Our Autopilot, automated document review for responsiveness, powered by GenAI, enabled a single attorney to complete the job on time, and Autopilot even coded out the issues. And this was a fraction of the cost of the managed review option that they had. So they chose between the managed review company and Lexbe, and we were able to get it done for them on time and way under budget. It also wasn't that long ago that cross-border cases required firms to have either co-counsel in country or the use of costly human translators, or perhaps both. But that's not the case anymore. Our GenAI-powered machine translation takes care of that job in short order with expert fluency. We also have a customer that's using Lexbe Copilot as they're going through their document review to analyze complex medical records from multiple different medical record systems, and it's creating summaries in the same format and a timeline of events. Lexbe is also lightning fast. We have over 10,000 CPUs that power our eDiscovery platform, and it's capable of processing over 1 million documents per hour. We did have one client recently upload 1.64 terabytes of PSTs, which are email files, and they were able to review those documents the same day. Our digital forensics lab, staffed with Cellebrite and Magnet Axiom certified investigators, can help you collect the evidence for your case. We perform remote and on-site forensic collections from smartphones and social media accounts, text messages, Slack, Teams, email accounts, and a bunch of other sources, including drones. We're skilled at finding deleted messages that have really been critical in several of our clients' cases. So if you have a need for forensic collections, please let us know. We'd love to help you. If you'd like a demo of the Lexbe eDiscovery platform powered by GenAI, or if you'd like a complimentary digital forensic consult, please shoot us an email to sales@lexbe.com. We'd also like to ask for your help. Please complete the survey at the end of today's session. It helps us continuously improve our webinar program and bring you the topics that are relevant to your practices. And without further ado, I'll hand it over to Gene Albert. Gene?
Welcome, everybody, to the Lexbe eDiscovery webinar series. I'm Gene Albert, CEO of Lexbe, and I am very pleased to introduce today Craig Ball, who is going to be talking on drafting eDiscovery protocols. Let me go over Craig's biography. It's a cliche, but if there's anybody that doesn't need an introduction in eDiscovery, at least in my book, it's Craig Ball. He has done more than really anybody else that I'm aware of in moving the education forward on that. Craig started off as an attorney to a litigator, but has a career in eDiscovery, digital forensics, and education. And then more recently, his career served as a special master and court-appointed expert in a number of matters, including some of the most technically sophisticated ones in litigation in the United States. He also is teaching at University of Texas and Tulane Law Schools in eDiscovery classes, which is critically important. In my opinion, our opinion ought to be done a lot more than it is for new lawyers. And he's also founder of the Georgetown University Law Center eDiscovery Training Academy, and serves on the faculty for that. Where everybody may know Craig and remember him is for years he was writing a volunteer column on eDiscovery forensic issues that was in a lot of technology news, and then a few years ago switched that out, and you now publish that in your blog at craigball.net. Craig also maintains another website called craigball.com that includes massive number of materials and some of the best or the best that's on there for eDiscovery and forensic matters. One thing that's there at that site I want to call out is Craig has what he calls, or misnames perhaps a little bit in my book, the electronic evidence workbook. And Craig uses this for his classes, and he's incorporated a lot of his previous writings there and kind of digested it together. But this thing is running at 617 pages for the last version. It's freely available, and it's really a go-to guide for me and others here at Lexbe for substantive matters and practical advice and wit, on eDiscovery matters. And if it's not covered in there, probably nobody's thought of it yet. You'd be the first one if you don't find something important that's in there. What we're doing here today, and it takes a while to move through Craig's biography, is Craig has published what he's called an annotated ESI protocol that was released sometime last year, I think. Yes. And a number of us have written ESI protocols, including me, but I think this is the best one out there. It's the best of the breed and really gives a lot of practical advice and takes one through the process. But most importantly, is it's annotated. I'm not aware there's really any other one that the degree Craig has gone and just explained why these materials are there and what's important about them. So I would recommend that closely for anybody in this area who is the litigator, and certainly anybody interested in this. One thing that I think is really underappreciated about these ESI protocols, in my own experience with it, and why we think this is so important, is that it really is outcome determinative in cases. And I've seen my share in the time we've been practicing of people that have just gone in and have signed bad ESI agreements when they really haven't understood what's going on, and it really, materially affects their ability to get evidence into the court if they've done something wrong on the ESI protocol. So I think that's a shame that actually goes on, and you're really well advised to know this area very, very well. So with that, I will turn things over to you, Craig. Thank you.
Well, thank you, Gene, for that very generous, kind introduction. I'm really glad for the opportunity to talk about protocols, and I feel like I have to come out of the box almost saying what Gene just said about outcome determinative could be terrifying in the talk about protocols. And there are certainly people out there today who are pushing back on the idea of protocols. And so I want to make clear from the beginning as I talk about this thing that I published last year called the Annotated eDiscovery Protocol, which hopefully is coming up on your screen at this very moment. So there's a story behind almost anything I do, some of them interesting and some less so. And this one goes all the way back to 1982, when as a freshly minted young lawyer out of the University of Texas School of Law, where I now teach many years later, there I am being sworn in on my first legitimate day as an attorney at a federal court. I don't even recognize that skinny, dark-haired kid either. But no,
a handsome-looking guy there.
Well, what happened? The ravages of age. So I was very fortunate out of law school. I went to work for the premier plaintiff's personal injury law firm in Houston. That's at our offices. And I was assigned my office as an associate. And as I went up there to that office, on the bookshelf were a series of books called Miller's Standard Annotated Insurance Policies. Now, if anyone listening has ever practiced in the personal injury arena, you know, of course, that we say that lawsuits stand on a three-legged stool of liability, causation, and damages. But if we were completely frank and pragmatic, we'd say that at least in the personal injury world, lawsuits stand on a much more critical fourth leg, which is the ability to actually get compensation for your clients, to get paid. And so these books brought a green lawyer into the world of making insurance coverage apply, how to plead and prove cases to get paid. And that was just finding the goose that could lay the golden egg early in my fledgling career. And I felt I owed a debt to that format, the idea of having the provisions on one side and the annotations explaining what they are and how they work and what matters and what doesn't, in a sense, alongside it. So when I wrote this document, the Annotated ESI Protocol, I elected to first try to synthesize many, many different protocols. I didn't invent the protocol. What I wrote is certainly not the last word in protocols by any means, but I saw a lot of mixed bags of protocols out there, some of which used loose or inconsistent language that had provisions that didn't strike me as being particularly efficient or modern or effective. And so I combed through these and tried to synthesize an exemplar protocol and then take the key alternatives that lawyers should be thinking about in negotiating and drafting these protocols, and first explain what they are and why they matter, and then talk about some of the pitfalls and perils to making what I regard as poor choices, but leaving those choices in there so lawyers can go the way that suits them best. And at the same time, I hope I've succeeded at leavening in a certain amount of consistency so that these things mesh well. That said, so if you look at it, you'll see just that. I'll take something as banal as unitizing documents for hard copies, which is a bit old-fashioned, but we still have to slipstream hard copies into our ESI protocols, and that'll explain what the language means and why you do it and how you do it. And although I've long been dedicated against the lazy practice of simply deploying forms, changing a few things, not really looking at the propriety of a form for your particular nuances of a matter. But I came to realize that if you don't give lawyers a form to start them off, you're not going to get traction on the important issues they need to consider. So the payback of sorts of plowing through the explanations of the provisions is the presence of an exemplar protocol that I hope you might find useful as not anything perfect, but as a jumping off point for your work. And I've updated this periodically as recently as the end of 2023, and even more recently to add in something called the EDRM MIH. So what are these ESI protocols? For those of you who haven't dug deeply into them, I define them as setting out the routine obligations of the parties respecting preservation, identification, and forms of production of ESI. Generally, most often these are simply an agreement between the parties with which the court has little interplay. Occasionally, they are imposed as a court order, especially when the parties cannot see eye to eye on arriving at a protocol. More complicated, and I would argue sometimes overly contentious protocols early in the case try to deal with TARP validation, various forms of search, and aspects of confidentiality. All of these are important issues. They certainly have their place in negotiation and agreement, but I'm going to make some different arguments today. I'm going to try to argue that there are core provisions to these protocols and that it's ideal, starting out at least, to keep it simple and to stick to those core provisions. A protocol need only deal with the forms of production, whether that be native or TIFF plus or a hybrid production formats. I'll talk about those in a moment. They should specify the metadata fields to be collected, protected, and exchanged in load files. They should set parameters for such prosaic acts like scanning and text extraction, optical character recognition, and some of the things that allow for image documents to be minimally useful. They should address Bates numbering protocols and the medium of production. The form of production are the forms the files or images take. The medium of production is the way that information gets from one side to the other, whether that's a hard drive that's delivered overnight in a secure manner or by an upload, etc. And they should also address very useful, highly technical issues that shouldn't be contentious, that will help your vendors like Lexbe and others, help them know how to best serve you as a customer by things such as deduplication, logical unitization, and the threading of emails, just as examples. Finally, pinning down privilege logging processes. These you may already be asleep just having heard me go through those various core provisions. But if you can get those down, and honestly, in my experience, if you try not to bite off more than should be chewed at the beginning, you can and should get those things down, because that sensible core protocol serves as a framework for further consensus. Being able to work out an agreement on just the basics shows both sides several important things. First of all, it allows you to know, and it allows you to demonstrate at the very earliest moments of a case that you're competent or not, that you understand issues of ESI and eDiscovery or do not. And I think that's kind of a litmus test early on of whether you're dealing with someone who's serious, competent, and acting in good faith, or if you might be running into yet another person who will talk a good game, bill out the hours of the back and forth of negotiation, but never meaningfully wants to get towards a protocol. And then we know to back away, offer the right things, and if you're getting no traction on even the simplest core provisions, it's time to take it to the court. It also allows us as litigants to consider where we stand. Have we done what we need to do to understand the ESI in our case? And are we prepared to deliver and meet the obligations we seek from the other side? And so once again, I'm not an advocate for these protocols calling for long drawn out, expensive back and forth red lines for months. That's the kind of thing, and that's the kind of behavior among lawyers that I think undermines some of the value of protocols, value that we can reach simply, easily, and quickly. Getting a protocol in place on core provisions means that both sides can begin exchanging those things that are readily accessible, the things they know they're going to have to produce, the things that are at hand. And in that way, allow the parties to learn about the case, perhaps determine their exposure in the case, the weaknesses in their claims, and move us closer to resolution as a form of early case assessment. So focusing on the core...
Craig, could I interrupt you?
Certainly.
Yeah, I had a question on this one. I think this is a really powerful point and something that I hadn't really thought of in my own approaching to it. And because I really come from the other direction. I'm one of your people that, throws everything in there and tries to get it all at one time. And I think I've a couple of reasons for that. One of them is just my background as a corporate lawyer. If we get an opportunity to draft an agreement, often we try to get everything we can in there, much more than the people with litigator backgrounds, because we're not sure we're going to see it again. But secondly, as I have read over the years, the cases when the judges will go in and interpret ESI orders or protocols, they sure seem to stick by the letter of whatever was written, good or bad. So I haven't seen a lot of opportunity once one of these things gets written, if you decide you need it in your case or that there's a lot of opportunity to go back and renegotiate it, at least in front of the court. So it seems like there's some trade-off here that if you don't, if you stick with more of a basic approach on the front end, you may have a hard time getting it into not only an amended agreement with the opposing party in the case, but also getting a judge to do anything other than what was written for good or bad reason on that first ESI protocol that comes out. How do you see that?
Well, I think if you're sticking to the less contentious core provisions, there's less chance you're going to find yourself in hot water because you injudiciously agreed to something you didn't fully understand and appreciate. That's why I see this as a process, not as something that everything gets hashed out at the beginning, because we don't always know all the answers. It's been my experience, Gene, that courts don't hold people to protocols unless the court is persuaded that people didn't do their homework. I mean, there are things you can know at the beginning and things that you may not be able to know, even with diligence and competence. And so if you go to a court and say, Judge, we agreed to these things, here's what we did and why we felt this was a suitable approach. But as we've dug into it, we've learned that we have certain legacy forms of data, or we've recently incorporated certain kinds of data that is not lending itself to the forms and workflows that we agreed upon. We're not trying to reinvent the wheel. We're not trying to back off materially and cause the other side to have an expensive and do-over. We are simply trying to tweak something because we have new information despite our diligence. And I think courts are willing to listen to that. Courts are not naturally punitive. And so if you've done your work and you've kept it to the core, fine. But if you come in and say, Judge, out of the box, we wanted to show we were good folks, so we agreed to do native for everything, and now we find we have a lot of redactions, and they want us to redact natively, and we don't know how. That's sort of foolishness, a big do-over, that kind of waste because you hadn't done your homework quite properly. Courts are not willing to start over. So it's all on the circumstances, but no litigant who has encountered an unforeseen circumstance despite diligence and competence, no litigant to whom that has occurred should hesitate to go first to the opponent and say, look, can we look at these? We both misunderstood what was happening at the time. Can we work this out? And again, by having built a culture of, if not cooperation, at least a certain amount of transparency and good faith, the likelihood that you've established your cred with the other side on protocols so that if you have to tweak it, they're willing to listen, this works. And if you just can't do that, then of course, go to the court, lay it out for the court, and give the court the chance to make it right. The cases we read about are the ones where that didn't happen. We don't read about the ones where the court did adjust the protocol or where the parties tweaked it because of unforeseen circumstances, because those don't result in orders and contentious orders and judgments. So naturally, what we see reported are the places where the system didn't work. And I think those are more the aberrations than the rule.
They're great point all. I hadn't really thought about that. And then I guess if somebody really had an issue with that, you could always draft like a non-integration clause or something just to be clear that you weren't meaning to cover the complete scope of all things that could be determined. I don't remember if you have that in your protocol or not, but I'm sure that's addressable. But great point. Thanks.
Well, I understand what you said. I can hear that corporate lawyer background. We all want to leave escape hatches to obligations if we can, if we're the obligor. But these protocols are designed to allow the parties to move forward. And so we have to have a certain reliance upon, say, forms of production, Bates numbering. Again, these are very core, very basic things. But I don't think you want to have to always be going back to the well on these things. So as I've been saying, don't expect too much from the protocol too soon. Yes, you will get to some of the more contentious things like search and tar validation, perhaps, but don't try to do that off the bat. You'll see some common objections, and I think your remarks are a great segue to this, Gene. We need to stay flexible. This is something you're trying to find consensus. That's a cake and eat it problem. You can't agree to things, get people to move forward on the strength of those agreements, and then just decide blithely at some point, no, none of that matters. King's X, we had our fingers crossed. I mean, I think there has to be a certain amount of integrity of process in this. And that's why I try to keep the focus not on things that go haywire, like trying to address the scope of preservation, the scope of search, et cetera. Things that do change and morph over time in serious and in ways that implicate a lot of cost and burden. But to try it again, stick to the core. Don't make a protocol the whole case. Make the protocol for ESI do what it does well, which is establish the basic standards for how we move forward in the exchange of ESI. So we need to stay flexible is something of a non-starter to me. Find out where you can know something. Do your job. We don't say that, but it's essentially do your job. Find out what your people have. Find out what they can do. Find out the forms it's in. Talk to your vendor. Find out what they can produce and what they can't produce. This isn't something you find out 6 months or a year into the case. I mean, we've been doing eDiscovery for 20 plus years at least now. Isn't it time that maybe we know, put a legal hold in place, talk to your clients, determine what has to be preserved, go to the EDRM, identification, preservation, etc. It's not rocket science anymore. It may have felt that way in 2006, but Gene, for heaven's sakes, it's as old as the iPhone. Anyway, moving right along, never agree to things you don't understand. That's why I wrote this protocol. Not a form to adopt blindly, but something that explains what these words mean, explains it so lawyers can understand it. And work with a vendor, work with someone who does understand it. As I like to say, learn it, get help, or get out. Don't get involved in a case that centers around electronically stored information and expect you're going to sidle up to the judge as it was 20 years ago and go, Judge, I don't get this electronic stuff, because those days are long gone. Those are the cases that you talked about a moment ago, Gene, as often as not, where somebody has agreed to something and they never even bothered to check if they could meet that obligation. So do your homework. Court-ordered protocols lead to sanctions. Well, violations of court orders can lead to sanctions. And I think for both sides, that's not a bad thing. Courts need to, and to protect their jurisdiction and protect their power. And so I recommend, if you think you're dealing with an untrustworthy opponent, there are advantages, significant advantages, I'll talk about in a moment, to having them entered as a court order. And protocols get too far down the weeds. I hear that objection. This stuff's technical stuff. Well, These are technical issues. Again, vendors need to know. They need specifications. You want bids from vendors as to what things are going to cost and how long things are going to take. You're going to have to give them some answers to some of these form questions and so forth, so they can say, we can do that readily. We do that with a checkbox, or that's a little more complicated for us. Here's what we can do instead. So the scope of the paper is too much for me to go over here. So I just want to pick out a few highlights, if you will. And one of those is, are these ESI protocols compulsory? And I can give you the classic lawyer answer of it depends, or yes and no. And so technically you can read the Federal Rules of Civil Procedure cover to cover, and it's never going to tell you the parties must submit a protocol. But it will say that the parties must enter into a discovery plan. 26F is going to require the parties to confer about issues of preservation of ESI, former forms of production. Specifications can be made by the requesting parties for that, and issues of privilege. So the rules contemplate that the parties will discuss and agree to, or failing agreement, get a court order as part of a discovery protocol entered by the court. So you can call it an ESI protocol or a series of meet and confer agreements. I don't really care what you name it, but the vehicle of the ESI protocol is, I think, an optimum way to approach these issues. So should they be court ordered? I've touched on this. I find, and your mileage may differ, but I find that judges guard their authority more jealously than they guard litigants' rights. That's not a slam on the courts. Courts have to protect their power. If court orders are not followed, everything falls apart. And so if someone, after having brought these issues to the court, having the court issue a specific instruction on core provisions of what the parties need to do, and someone simply doesn't bother to do it, that's going to incense a judge. And so, yes, you are more likely on the first instance to see either a remedial sanction or perhaps even a serious sanction in the face of spoliation with intent. But most of that doesn't come out of protocols. Courts fix it, but courts rarely come up with anything that's a decisive sanction, or certainly not a what we call a 2E sanction, a serious sanction coming out of Rule 37. But if you want a protocol with teeth, get it entered as an order. Now I'm going to talk, if you wouldn't mind, Gene, I want to talk a little bit about forms of production. With forms of production, people kind of ask, do the forms of production really matter? Particularly, what should we say? More experienced lawyers like you and I, Gene, people who have the wisdom that comes with of silvery hair. I mean, we're still hearkening back to the days of paper, and so often, do the forms of production really matter comes up, and isn't something kind of like a printout gonna work? Is it good enough? And the answer is, there's a difference of view here, and a lot going on. Perhaps the most contentious issue, but it doesn't need to be. And I started using lately an analogy of aspect ratios of video. Most of us who've bought a television in the last 10 or 15 years have thought about aspect ratios, but I go back a long time. I was born in 1957, and back when I was watching movies on TV as a kid, movies until 1953, before I was born, movies were filmed in what's called the 4:3 ratio. It's a little wider than they were tall. And they fit those old TVs pretty nicely. But the movie studios back in the day, they were scared that TV was going to keep people from going to the theaters. So they tried all kinds of things, widescreen, CinemaScope, Cinerama, Panavision, all these things, so that screens got wider and wider and wider, and movies got wider and wider and wider. And as we tried to put one medium onto another, watching a movie on a TV set, so a widescreen film on an old-fashioned TV, or an old TV on a widescreen television, we had things that required pillar boxing and letter boxing. So we only got to see part of the image, and viewers hated that stuff. They just hated it. So broadcasters started doing a thing that many people don't even know about called pan and scan. And it happened that not too long ago, I watched an old epic called Ben-Hur. And Ben-Hur had this famous chariot race going on. And this is a stirring moment, one of the most famous in movie history. And because it was wide, you couldn't see it all. So what the TV people started doing is they would pan and scan. They would only show part of the widescreen image, the part they thought maybe was most important, and then they would go to another side. And so people watching these movies on television were none the wiser. They were missing all the epic wonder of these shows because of this pan and scan, but they didn't really understand what they were missing. And I think it's like that for ESI that's produced in static image formats. You just don't know what you're missing, and turning to things like TIFF images, you're paying more for less. And I argue, what's the optimum unitization for eDiscovery? I mean, documents, pages, lines, as we do, say, with depositions. And I think the answer is files, because applications store information in files, users use files, lawyers collect files, you process files, dedupe files, etc. And so the evidence is the native file. That's what the witness created and used. That's what we can authenticate and preserve and collect. It's got the richest and most defensible information payload. Yet when many producing parties hand off ESI, they do it in TIFF plus formats. For those of you who don't, please, sure.
Could I make just a comment before you move into the TIFF, just to add on what you were saying? One thing that just that really blew my mind when we first got into, when I started learning about eDiscovery when we started this earlier, was that with the Outlook files, the Outlook email files, and I'm not sure if it's still done this way, I haven't kept up with it, but there were actually different versions of it. So there's different text containers within an Outlook file and some of the older email file formats. So they're really, and then it would display differently depending on what browser client was being used. So there was no right email that made it onto paper. It just depended on how you accessed it and how you printed it. And sometimes they're exactly the same. Sometimes they're very close to the same, but sometimes they're not really the same at all. You know, they could theoretically be quite different. So that may not be email anymore, but with all these new data types coming out, there just isn't some printed version that you could reduce to even theoretically. So, you know, you really are, it's really the mistake to think about it as anything other than the most complex electronic file.
Well, you make a great point, Gene, and I think even people pretty steeped in electronic discovery and ESI may not appreciate that every email that you send or receive actually sends two different copies of the email, one that is in a rich HTML format and a much more basic plain text version, because this is the way emails are designed to traverse even the oldest systems. So if in processing, the less rich version were imaged instead of the more rich version, I could see how that could create serious problems in terms of color, formatting, italics, everything could go wrong there. And I don't even know if that's the problem you're talking about. There are a lot of issues that come up when you try to reduce information that's born electronically into a TIFF image. And on the TIFF image, just to go back to this, a native JPEG photo. Here's a photo from a very high-profile bit of litigation a couple of years ago. If you were to produce this colorful JPEG image as a TIFF image, it would be stripped of all its color, because a TIFF image, a tagged image file format image, is a black and white rendering, one image per page typically, with no searchable text and no native metadata. And I know people are immediately pushing back going, what do you mean no searchable text? Let me get there, because TIFF doesn't contain searchable text. Here's a native PDF with color used to denominate fields of information. And you see the challenges we see reducing this to a monochromatic image like on the front. And again, the TIFF image has no searchable text by itself, no pocket, if you will, as we see with a PDF, where a PDF might contain searchable text. TIFF images do not. So here we have a kind of a rogues gallery of the rich and famous: King Charles, Pope Francis, Warren Buffett, Tom Cruise, Beyonce, and Jeff Bezos's former wife, Mackenzie Scott, the great philanthropist. Now, these people don't live like we do. They're richer than we are. They may be smarter than we are. They have more followers than we do. You would think that they would live a better life in every respect. But you know, here's the great leveler. If any of those celebrities were to go and create a spreadsheet or a word process document or a PowerPoint or whatever, they're going to use the same operating systems and the same applications that we mere mortals use. There's no special windows for rich people. And so we've used those native formats for many, many years. They are original, searchable, and they are complete by design because they are the evidence. But when you make a TIFF image conversion, instead you get something that's much less, not original, not searchable, and not complete. But because the law requires that we must produce, under federal civil rules certainly, we must produce some level of searchability. We cannot degrade it so materially as to eliminate it. The practice has become to try to add back a kit, so to speak, that crudely reestablishes a level of searchability by producing so-called load files with either extracted text or created text through optical character recognition. The problem with this, and there are many problems, but beginning with just the dollar cost, is these TIFF files are many times the size of native. So accordingly, in modern times, with the use of hosted providers where we pay by the gigabyte, often by the gigabyte per month, we pay more and more if we use fat forms versus skinny forms. And now you and I, Gene, you've been very helpful to me over the years in debating what that distinction is and so forth. And so the hard, fast rule, I would say, is more. How much you're going to pay? More. Sometimes much more. But another thing is functionality. You saw that colorful slide I just used to talk about it. Everything you saw was a single slide. Turned into a TIFF image in production, it would look like this. Functionally useless, overlapping, not searchable, color disappears. And again, cost being the clincher. I will invite people to test it themselves. I've done it where it's 15 times larger than the native. That's a lot. How would you feel to be charged 15 times too much by anyone today for anything? And I know you perhaps and others are saying, come on, Craig, 15 times too much. Am I a fool? Are you telling me I've been victimized to that extent and I didn't know it? Well, I don't want to point the finger. So when I am teaching my students at the University of Texas, I have them test it themselves. Don't take my word for it. Do actual productions and test it yourself. And I do this with my law sections, my information science students, my computer science grad students in digital evidence and discovery. And they process a data set. They export it in native. They export it in a standard TIFF plus load file using standard settings, not gaming the system, and then compare the size of the two alternate sets. And then I ask them to tell me, what did they find? Better that they find it out for themselves. Busy lawyers don't have time to test it for themselves. But unless they want to keep paying multiples too much, unless they are willing to let their clients be victimized in that way, and I honestly believe the vendors are not the problem here. Vendors are willing to produce in native. Vendors like you, it's basically a tick box to produce in native. So saying to a vendor, I want native versus TIFF plus, vendors can still make a good living that way. So I'm not pointing the finger at the vendors benefiting from this, but the vendors do often charge by the gigabyte. So the more you ingest, the bigger, fatter file, the more you pay. And so many people push back on redaction. They go,
Craig, I can make a comment on that. And as you say, we've been discussing this for many years. We favor the PDF, as being a very good compromise. When we started this 20 years ago, I had bet I thought there would be no way that TIFF would still be used to the extent it is in the industry. So I would have lost that big time. And then we like the PDF because of as you talk about that in your paper about the attributes of that, and then we'll bring in the TIFF as needed, and then we have the natives as well going out. On the size, it really varies quite a bit. I think the last time we looked at our data, the PDF, if properly created, and that's really the big issue, on average is about the size of the native. So we usually see about a 1x there, and that's because the mechanisms that they would have in Office and in the PDF on trying to optimize the data that's provided in a rich format within those complex file types ends up being pretty similar. So more or less, it's about the same on that, subject to some minor compression and things. And then the TIFF ends up being 10 or 15 times bigger than either one of those. And the reason you'll see things that are kind of strange with the PDF is it depends on how they're created. So if the PDF is created straight from a native and it's done properly, on the software that does the process of that, it doesn't end up making it much bigger than the native. So you've doubled it for the benefit of having the TIFF, the PDF or whatever it is. On the other hand, if the process, and particularly on some of these systems that are more TIFF-centric or image-centric, are that they create the image first and then make it into a PDF, or they make a TIFF first and then they PDF the TIFF, and now you're up at that 15x. So we see a lot of confusion on that point as well.
TIFF has much to commend it, no doubt about it. Certainly its native support of color, the ability to embed searchable information in the file, much to commend it. It's not supported by many people's review platforms, and that's been brought forward as an argument over the years. I think we need to move in the direction of native. I don't know that we necessarily need to get there every time. We certainly must move away from TIFF. TIFF is incredibly wasteful, non-functional. You can redact in TIFF. You can natively redact in PDF. PDF does a fine job of redacting at both the searchable text layer and at the visual layer. So we can debate that. I think we're going to agree, if you're doing a TIFF plus, you're doing a disservice to the justice system. I'll be that broad. If you're using PDF, you're being much more efficient and providing a more functional form. I would still argue for certain things, PDF is not an optimum form for spreadsheets. It's not an optimum for PowerPoints, not an optimum form for any kind of rich media like sound or video, all of which are natively supported by native production. And so PDF has its place, but it's not a complete solution, where native is a complete solution, even for many forms of redaction. And if you just can't do native redaction, you want to go back to TIFF, my attitude is fine. Don't let the redaction tail wag the production dog. By that I mean, if you're going to mess up by redaction a small percentage, a tiny sliver of an overall production, then don't damage the entire production and make it so much more costly. Isolate the things you're going to redact, mess them up by whatever redaction form you want to use, including, heaven forbid, print it out with a black magic marker and scan it back in, because you're going to mess up that evidence anyway. I'm not going to get fully functional utile evidence once you start black marking on it. So let's segregate that process and keep the efficiencies over the overwhelming balance. Bates numbers, a lot of bad information is, you hear people say, Bates number, you can't Bates number native. Well, that's ridiculous. You can Bates number, but we do it a little differently. We do it a little smarter than simply embossing on a page. ESI is files. You can Bates number the files, and you wait then to add pagination until you convert it into formats that require pagination when making a record. And so, putting this in the context of the EDRM, the producing party never gives up their power to assign Bates numbers to a native production. Let me make that clear. They still do that in the processing step, in the production step, before it goes across the fence to the other side. They control Bates numbers. They get to impose the requirement that Bates numbers appear on any form that is derivative of what they produce. That's in this protocol. But the Bates numbers then that are numeric, I don't mean to say numeric. Bates numbers are numeric, alphanumeric. But the pagination gets added when it's changed into a paginated form. If you print something out to hand it to a witness in deposition, you'll then emboss the Bates number that was chosen by the producing party, as well as a page. All the systems I've seen, all the good vendors, all of them make provision for being able to have that two-part Bates numbering if you have to reissue as a TIFF or a PDF or, heaven forbid, print it out. So we've been doing this sort of thing for years. We've been Bates numbering TIFF images for years and years. This is not rocket science. It's not rocket science. Okay. So let's finish this up by saying the annotated ESI protocol provides a treatment of both. You want to be mostly TIFF, you want to be mostly native. I don't make that decision for you. I provide those alternatives and an explanation of the strengths and weaknesses, both in terms of cost, utility, completeness, authentication, searchability, and allow you to make the decision as the captain of the case, the lawyers in the case. And when you choose your form of production, you should be matching it to your needs. What do you need to do with the evidence? What do you need to know about the evidence to authenticate it, to challenge it in court? Can you reap the benefits of native forms? Those benefits are manifest. Those benefits are significant. But if you're trying to use very, very old tools, if you just don't know how to handle native production, if you're going to do something stupid, maybe you need to be protected from your own incompetence and just try to use a browser with no searchability to TIFF images. I think you're hurting your clients, but we'll leave it there. Don't be so desperate to get something in a hurry that you agree to accept anything. Hold firm to get the right forms, because I've seen too many requesting parties who say things to themselves like, if I can just get something, this is such a winnable case. If I just give me some of what I've asked for, we'll be done. And they make concessions. They get forms that cost them a lot of money, that don't allow them to get the evidence they need to understand what they're seeing and to get it into evidence. So don't be so desperate to get something that you agree to accept anything. Yeah, I'm going to skip through because I'm running short of time, Gene, but this was an interesting case, this Boulder Falcon case from last year, where there was a production, and it's kind of emblematic of when lawyers get involved, they see a TIFF production, they don't understand what they're getting, they don't know what a load file is, they don't talk to each other. And so there's a lot of back and forth, a lot of browbeating, and ultimately counsel gets sanctioned severely because counsel didn't understand what forms of productions were all about. Let me just skip through that and see if we can't wrap this up with a few more points about metadata. The annotated ESI protocol lays out the menu, if you will, of available metadata fields, some that I consider to be so-called metadata musts, MUSTs, the things you should never fail to request, and what they are, and examples of how to produce them. So some of these things may not be important to you. Some of these things I think should be very important to you. If you're interested in this, Gene was kind enough to mention craigball.net, also Ball in Your Court, ballinyourcourt.com, where I have a blog, craigball.com, where I'm multiple free guides. Not going to try to sell you anything, including my services. So the annotated ESI protocol is at craigball.com. Lawyer's Guide to Forms of Production, Modern Requests for Forms of Production. There are dozens and dozens of articles over the years that I hope that you can use to help jumpstart your education or add to your already existing deep knowledge of ESI and electronic discovery. And Gene, I'm going to turn it back to you now. If there's anything else you would like to discuss, I will release the screen, if I may.
Well, Craig, thank you. That is just fantastic. we could spend hours for this. I for one, be happy to be in the weeds for this. I think it's such an important subject, but we're up on our time for one webinar. We will have links to all this on our site too when this webinar is being shown for on demand. And Craig, just thank you again for your time with us to go over this on this important subject, and for all you've done, in general for the industry. We really appreciate it.
You're too kind. Thank you for the use of the hall, as it were. And if I could just get one quick last word, folks, don't listen to the people that say ESI protocols are nothing but a headache. That's in the execution. Work to find the core. Keep it simple. Don't let scope creep into protocol. If you're arguing about the scope of a protocol, you've missed the point of what an ESI protocol does very well. So keep it simple. Don't boil the ocean. Find common ground. Work in good faith. Work with your vendors, and you'll find that ESI protocols can be your new best friend. Thanks a lot.
Great. Well, we'll wrap it up with that and turn it back over to Jeff. And thank you very much, and thank you for listening.
Thanks, Gene and Craig. That was an insightful and entertaining discussion on ESI protocol best practices. Lexbe is leading the GenAI revolution in eDiscovery. We're seeing corporate legal departments adopting GenAI solutions at record pace. And if you're in a law firm, you really don't want to be on the wrong side of this rapidly evolving technology. It is game-changing. Legacy document review was time-consuming, expensive, and reactive. GenAI shifts this paradigm by automatically surfacing key facts, entities, and patterns, turning millions of documents into actionable case insights in a fraction of the time before. Lexbe's GenAI suite delivers high-speed analysis without sacrificing accuracy or defensibility. From timeline construction to privilege identification, GenAI accelerates review while maintaining the rigor required for litigation. And unlike legacy platforms, Lexbe has incorporated GenAI tools throughout the workflow, and they're built for the complexities of litigation. Pilot generates instant case summaries and deep case insights. Copilot assists attorneys and paralegals during live review. Autopilot handles automated first-pass review with precision and at a fraction of the cost of managed review. Now let's tie those ideas back to how Lexbe equips legal teams with these capabilities so they can handle document-intensive matters with ease. Jordan Howlett is a litigator who heads up a multi-office boutique firm. He often faces off against larger, well-funded opposition. With Lexbe Copilot, he quickly assembles fact-rich narratives that give him an edge in litigation. David Jones was concerned about being outmatched by his AmLaw competition, but Lexbe's GenAI-powered eDiscovery platform gave his team the upper hand and a verdict to match. Paige Tackett with Thompson Co. had tight deadlines, and Lexbe's processing engine, powered by more than 10,000 CPUs and processing over 1 million documents an hour, helped her go from ingestion to production in record time. And Jessica Wiebe with Lightfoot manages a heavy caseload that requires an optimized workflow. Lexbe's GenAI-powered features are critical for achieving efficiencies and helping her hit those deadlines. That brings us to the end of today's webinar. On behalf of the entire Lexbe team and our guest speakers, Gene Albert and Craig Ball, thank you for joining us today. We'll be making the following available to you: a streaming video version, a downloadable PDF presentation, and an MP3 podcast. Be sure to follow us on LinkedIn and YouTube to stay up to date on our webinars. And please take a moment to complete the short survey that's about to pop up. Your feedback helps us make each of these sessions better than the last. Until next time, stay sharp and have a great weekend.